Legal and Privacy Brief for February 17, 2026. The Fourth Circuit established a procedural framework for prediscovery class certification challenges in Oliver v. Navy Federal Credit Union, 2026 WL 346144, replacing the improper use of Rule 12(f) motions with a combined Rule 23(c) 1(a) and 23(d) 1(d) approach that draws de novo appellate review. The Centers for Medicare and Medicaid Services issued a proposed rule that would strip Medicare and Medicaid funding from hospitals providing gender-affirming care to minors, drawing opposition from Epic on patient privacy and federal coercion grounds. Multiple California localities have terminated or suspended contracts with Flock Safety after federal agencies, including ICE, accessed automated license plate reader data in violation of California law prohibiting disclosure to out-of-state and federal agencies. Here's the full breakdown of today's top legal and privacy stories. Next section, Litigation Updates. Oliver v. Navy Federal Credit Union Fourth Circuit Class Certification Framework, 4th Sir. 2026 WL 346144. The Fourth Circuit ruled February 9, 2026, establishing the proper procedural mechanism for prediscovery class certification challenges. 9 mortgage applicants alleging racial discrimination by Navy Federal Credit Union in residential mortgage lending brought 2 proposed classes, one under Rule 23(b), 2 for declaratory and injunctive relief, and one under Rule 23(b), 3 for damages. The district court had dismissed both class allegations using Rule 12(f) motions to strike. The Fourth Circuit held that Rule 12(f) is the wrong vehicle for class challenges at any stage, directing instead that defendants use a motion to deny class certification under Rule 23(c) 1(a) coupled with a motion to strike under Rule 23(d) 1(d). The court found prediscovery denials of certification are legal determinations reviewed de novo on appeal, not for abuse of discretion, vacated the Rule 23(b) 2 class denial. The complaint adequately alleged those elements, and affirmed denial of the Rule 23(b) 3 damages class for failure to sufficiently allege predominance and superiority. Compliance action. Defendants in the Fourth Circuit facing class complaints with facially deficient class definitions should use Rule 23(c) 1(a) rather than Rule 12(f) to challenge certification before discovery begins. The shift from abuse of discretion to de novo appellate review on prediscovery denials changes the risk calculus. A favorable district court ruling carries less deference on appeal, but a well-grounded motion has a stronger appellate record. Litigation counsel should update motion practice templates and assess pending matters for applicable reclassification. Source: Inside Class Actions. Next section, Regulatory Guidance. Epic comments on CMS NPRM. Medicare/Medicaid funding prohibition for gender-affirming care in hospitals. The Electronic Privacy Information Center submitted formal comments urging the Centers for Medicare and Medicaid Services to withdraw its notice of proposed rulemaking that would prohibit Medicare and Medicaid reimbursement for any hospital providing gender-affirming care to minors. Because most hospitals cannot operate without CMS reimbursement, the rule functions as an effective nationwide ban on the procedure in hospital settings. Epic opposition centers on patient privacy rights under HIPAA, the scope of CMS authority as a payer versus a clinical standards body, and the constitutional implications of using funding conditions as coercive levers over medical practice. The NPRM is currently in its public comment period. Compliance action. Hospital systems and healthcare compliance teams should flag this NPRM and assess operational exposure if finalized. Submit comments through CMS's official comment portal to preserve procedural standing for administrative and judicial challenges. Legal counsel should track whether Congress acts to restrict or codify CMS's proposed approach, and monitor any parallel state-level prohibitions or preemption arguments that may affect facility policy. Source: Epic News. Next section: Privacy Developments. California Alper Networks. Unauthorized federal agency access and flock safety contract terminations. Multiple California localities have moved to terminate or suspend automated license plate reader contracts with flock safety, following revelations that federal agencies, including ICE, accessed Alper data in violation of California law Cal. Vehicle Code Sec. 2413, prohibiting disclosure of Alper data to out-of-state or federal agencies. Mountain View Police shut down all flock cameras after confirming unauthorized federal access to the network. Los Altos Hills and Santa Cruz terminated flock contracts outright over ICE concerns. East Palo Alto and Santa Clara County are reconsidering their contracts. California Attorney General data shows at least 75 California law enforcement agencies shared Alper records out of state as recently as 2023. And San Francisco police documented 19 searches related to ICE in a recent reporting period. In San Jose, police conducted more than 261,000 warrantless Alper searches over approximately 14 months, nearly 700 searches per day, with no suspicion requirement before querying databases containing up to 1 year of location records representing hundreds of millions of entries. Siren and Care California, represented by the Electronic Frontier Foundation and the ECLU of Northern California, filed suit to stop San Jose's warrantless Alper access. Compliance action. Organizations that contract with law enforcement-adjacent surveillance vendors or provide data to Alper platforms should audit their data-sharing agreements for federal agency access provisions immediately. Contracts should include explicit prohibitions on federal and out-of-state agency access, consistent with applicable state law. California entities subject to CCPA must ensure surveillance vendor agreements include data processing addenda, specifying permitted uses and prohibiting unauthorized disclosure. Procurement teams evaluating Alper or mass surveillance infrastructure should include data access audit rights and breach notification requirements as standard contract terms. Sources: EFF Deep Links. Next section: Policy Changes. EFF Selling Safety Report. Accountability Framework for Police Surveillance Procurement. The Electronic Frontier Foundation, the Center for Just Journalism, and IPVM published Selling Safety, a guide for journalists and policymakers analyzing how police surveillance vendors construct claims of effectiveness and how those unsubstantiated claims propagate into procurement decisions and media coverage. The report documents that Alper providers, facial recognition vendors, and similar law enforcement technology companies routinely substitute marketing for evidence, and that lawmakers frequently accept vendor-generated effectiveness metrics without independent verification. EFF maintains an Atlas of Surveillance at Atlas of Surveillance, org mapping technology deployment across U.S. jurisdictions, and a street-level surveillance hub at SLS. EFF. Org providing accountability resources by technology type. Compliance action. IT and compliance teams evaluating police tech adjacent surveillance or monitoring tools, including employee monitoring platforms, access control systems, or AI-assisted security products, should require peer-reviewed efficacy studies rather than vendor case studies. Apply the same vendor due diligence standards used for security software procurement. Request independent audits, reference customers outside the vendor's marketing materials, and verify that effectiveness claims cite controlled evaluations rather than deployment statistics. Source: EFF Deep Links. Next section: Compliance Takeaways. Fourth Circuit Class Action Defense. Defendants in the Fourth Circuit should replace Rule 12(f) motions to strike class allegations with Rule 23(c)(1) A motions to deny certification, coupled with Rule 23(d)(1) D motions to strike if certification is denied. Pre-discovery certification denials receive de novo appellate review under Oliver v. Navy Federal Credit Union, 2026, WL 346,144. Assess all pending Fourth Circuit class matters for procedural alignment. CMS NPRM comment deadline. Healthcare organizations should submit comments to CMS on the gender-affirming care funding NPRM before the comment period closes. Monitor the docket for finalization timing. If finalized, facilities that provide these services will need to either modify programs or lose Medicare and Medicaid certification, requiring board-level policy decisions and contingency planning. Surveillance vendor data access audits. Any contract with a surveillance technology vendor, including Alper, body camera, facial recognition, or access control providers, should be reviewed for provisions governing federal or out-of-state agency data access. California law expressly prohibits Alper data disclosure to federal agencies, and violations are documented across at least 75 agencies. Non-compliant contract terms expose organizations to civil liability and regulatory action under state privacy law. Warrantless government data access exposure. Organizations that aggregate location data, movement records, or behavioral data through third-party systems should evaluate their current exposure to warrantless government requests. The San Jose Alper litigation illustrates that mass data collection without warrant requirements is under active legal challenge. Establish documented data minimization and retention policies before litigation or regulatory inquiry forces the issue. LLM deployment security posture. Research highlighted by Schneier on security identifies remote timing side-channel attacks against inference-optimized language model deployments. Organizations running customer-facing or internally hosted LLM services should monitor published research on speculative sampling and parallel decoding timing vulnerabilities, as these techniques develop from academic proof of concept toward operational exploitation. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.